verified voters. Let them know how many were verified at each of these polling stations. You don't know.
No, my God.
So again, as stated by you, that you are supposed to write the number of votes counted and tallied at the polling station. This they did not do. Is it your statement?
My Lord, is my petition. And the remaining.
They did not write the number of votes counted and
The
tallied.
polling agents, they mentioned why that was so from the 14 polling
Okay.
stations.
So you want us to state that the roles of your purported agents of verifying voters, writing the number of votes counted and tallied, and returning their forms were not performed, but they went on flowing into reporting only chaos, violence. You want us to believe you this statement?
Yes, my Lord.
And that despite that confirmation, you stand by your statement that voting went on from 7 to 4 as provided for by the law. Confirm. The only missing element.
According to the affidavits, my Lord. Yes.
Now that according to affidavits, again, probably this is your evidence, not these other people. We went through numbers where there was a presupposition that probably all people would turn up. You confirm, you do not know how many did. That's the confirmation statement.
Yes.
So if you did not, if you don't know the number, is it then attributable? Would it be attributable to your averment in paragraph 11? Because that's what you want to state. Are you attributing this to, again, the allegation that electoral materials and documents were destroyed? Is that the source of your information? I'm trying to make sense out of this budget. No agents, you not talk about this, but then you talk about it. Are you attributing it to the statement that electoral materials and documents were destroyed? That's paragraph 11. The 13 of your affidavit, 13, petition. What you have affidavit? Please let's restrict ourselves. I'm only on 2 paragraphs, 9, 10, 11.
I will state it, my Lord, the paragraph. I say that I'm further informed by the affirmation persons, which information I verily believe to be true and correct, that during the counting of the votes at the state polling stations, there was violence and chaos and commotion, as a result of which there was no results declared and transmitted for those polling stations. And second, the electoral materials and documents were destroyed.
So you confirm that there was counting. In paragraph 11, it's your statement, there was counting. You state this, you are reading it, there was counting. according to paragraph 11.
Yes.
You confirm. And that during counting, ordinary agents write. What's this counting? Ordinarily,
My
you
Lord,
confirm.
in an ordinary circumstance,
Yes.
yes, my Lord.
Did-
But this was not ordinary.
Between 7 to 4. Okay, counting people who have turned up to vote. 7 to 4. Ordinarily, would they write is turned up? Because you say you don't know the number of those who turned up. At least, what is that they gave you from the rolls as stated by you? It's not
My Lord, in the 14 polling stations, did not receive the results as mentioned.
So, are you running away from paragraph 11, aforementioned persons, that there was counting of votes at the same polling stations? Are you retracting this evidence? So that we know which you're retracting and
No,
what
my
you don't
Lord.
know. So you stand by that there was counting? Okay. Yes, going back to you attributing these issues to the materials destroyed, as you stated in paragraph 11. Can you state what you, Nambi, know the electoral materials and documents referred to? You just named those that were destroyed.
According to the agents reporting to me, my Lord, I was informed that the ballots,
Ballots?
the containers that carry the ballots,
Ballot
and then
boxes?
also the electric machines were some of the documents, the items that were destroyed on that day, and others were the desks.
Did you have such evidence in your petition on the ballots that were destroyed? In your evidence, you have any? Yes or no? Ballots, these ballots. Well, I'll take you back.
Yes, my Lord.
Yeah, you
They
have
are
information.
electro materials.
So
Ballots
ballots.
are still electro materials.
So ballots were one of
And
those.
the documents.
Do you know that one of the name, what happens at the polling station, the ballot books and number of ballots before you even commence, and the primary issues determined. There are two booklets and this number of ballots at the given polling station. You at least receive that information between 7 and 4.
My Lord, according to the affidavits of the agents, they confirmed that at the start of the elections, there was compliance.
So compliance at the start. How many ballots did Kalemba tell you? At least those which were destroyed because they are disclosed. Kalemba Herbert at Mbogo Primary School, you have such evidence. So that we are certain. Even number of ballots were brought and were destroyed. You have this in evidence.
I just got information about the polling stations where the chaos were destroyed.
You do not have the evidence about the number of ballot papers.
No, my Lord.
So I'm getting it that apart from the chaos, violence, even when it was smooth as stated, the agents did not report anything about the voting exercise,
No, my lord.
despite the calm. Okay, do you have evidence then on the containers, those are ballot boxes, in your petition? I need the evidence. How are they destroyed? Were they burnt down? Do you have any such evidence on the said containers, the ballot boxes, in your petition? Doesn't matter whether it's hearsay.
No, my lord, but it's encompassed in the electoral materials and
You,
documents that were destroyed. My lord.
so you leave it to us to imagine. Is that your case? Is it in this petition? How many, the number, and how?
No, my lord.
It's not. BVVK. What is the BVVK? Should be mentioned. BVVK. Educate me. You mentioned it as one of the, because I am imagining how BVVK was destroyed. And the information, most important. Tell us, you know BVVK machine?
The biometric machine, my lord. Yes, I know it.
Yes, tell us. About the BVVK. Tell us the purpose of a BVVK that you know.
Verify the voter.
So, is it true that you go to a polling station, it gets your forensics, and confirms that you registered voter at a polling station? Because you know it. Yes? Is it your statement? Because voting, you come, it verifies you. That is all I want. You registered voter. And it stores that information.
Yes, my lord.
So is it true that using a BVVK, even if your agents have negated to tell you, can you use the BVVK to ascertain the number of voters who turned up at the polling station? Okay,
I can.
you can. You can't, you went wrong there.
My lord, if every voter has used the biometric machine, they will be able to show that.
And you'll be capable of using it to ascertain the number of voters who turned up.
Yes, my lord.
Did you request for such information from the Electoral Commission? Assist. Did you or did you not?
No, my lord.
To your belief, would it have been essential? You are proving, would it have been an essential element? You are us know. It's not 100%. Like my senior colleague was giving you generously. Would it be essential?
My Lord, I would request the second respondent
Would it be
to
essential?
help us with the answer.
Would it be an essential element for this purpose?
Yes, my Lord, it's essential.
So to conclude on this, between the BVVK and information from your lawyers, I've seen it in paragraph 13 and paragraph 14. Where you say, I am informed by my lawyers and associated advocates with information. I very believe to be true. That there was non-compliance with the provisions laid down in the Parliamentary Elections Act relating to elections, and that the non-compliance and failure to hold elections in accordance with those provisions and the result. And further informed by my lawyers, with information I very believe to be true and correct, that the overstated failure and non-compliance disenfranchised the voters at the impugned polling stations, including myself, a voter at Nalukoola Primary School playground. Disenfranchised. Who would you choose as Nambi between the BVVK and your lawyers? Who would you choose to have better information on this non-compliance and disenfranchisement between the BVVK and your lawyers? Where would we get?
My Lord, if I had the biometric machines, would be them, but in this instance, they were not there.
What did you ever request for them? Probably. You said no. Would you then rely on the hearsay evidence from your lawyers if the BVVK were available? Would you then? Well, if you can't answer that, well, let me paraphrase it. Would I then be right to say that you ignored the BVVK for fear of the truth again in the numbers?
My Lord, they were not available.
Well, it is not very hard to ascertain why you do not know. It's because you are relying on information from people even where you confirmed you are not there, confirmed even the information of these materials from your lawyers. My Lord, I'm looking at information from paragraph 10, 11. I'm informed the Limbon agents is in 11, at 10, 11. You have 13, 10, 11, 12, 13, 14, 16, and so on. My Lord, the witness has admitted that all this evidence is hearsay. I heard from my lawyers, from my agents. I confirm some of them will not come to this court. My Lord, it's my submission on this issue that a party, my Lord, can rely. Actually, I can raise an objection at this stage, my Lord. I can do it during trial. And it's my prayer, actually, that all this evidence, paragraphs 10, 11, 12, 13, 14, and 16, 19, and so on, my Lord, all based on hearsay evidence. The same, my Lord, I submit is inadmissible. It cannot be considered during trial going forward. Because we are not making headway. Witnesses, will not be considered, and I pray that it be expunged. From record for being hearsay. Note 10, 11, 12, 13, 14, 16, all 16, 18, 19, all 19, 20, 20, largely that, my Lord. My Lord, the elementary style under section 59 of the Evidence Act, I pray that all these averments be expunged off the record of being hearsay evidence. My Lord, I submit that evidence, admissible evidence, must be of that witness who says he or she saw the given issue and was there, or heard. My Lord, specifically, we have several decided cases, one of them being retired Colonel Dr. Kiza Besige versus Real Capital Museveni. This area was canvassed, and the ratio was that such evidence would be expanded. My Lord, my colleague will submit on that authority going forward. Another, the starting point will be not really back in that. Really back in the report. Well, the starting point would be order 19, rule 3, 2, which is rule 3, 1 and 2. The effect that affidavit evidence must only be restricted to information by the deponent.
A lot of the courts have canvassed this area. It is a settled area. A lot of the cases are going to provide, but the actual authorities will be furnished with court letters to give permission. But not with that, with your guidance.
You have made your prayer and I will consider it the general evaluation of the I will consider it as I evaluate the general project.
A lot of understanding.
But I will capture your prayer.
But our understanding, my Lord, has been that now then how do we continue cross-examining on evidence that we have already indicted?
The other which is not processed. They don't process it because the one which you see is not here certified.
My Lord, maybe then that means that our objection has been sustained. They have been expanded.
I have said,
Because if you rule, we go forward.
I have said that I will consider it during the general evaluation. That's what they said. I didn't say I will consider it. So to be considered then, but you can continue with the examination.
Yes.
Have you completed?
I'm not, because on this issue, let him complete the submission.
Okay, you Mr.
Let's conclude the submission then.
Give the authority supporting your colleagues.
Yes.
And then you can move.
But my Lord, the first one is Paul Kamanga, Semobi, and Zachary Alum versus the Attorney General. Constitution petition number 3, 1999. We also have Chris Mobilu. I'll give you the rationale. Chris Mobilu, that is the Attorney General. Constitutional petition number 1, 2001. My Lord, we have Chiza Besige versus YK7, presidential election petition number 1, 2001. My Lord, this is the rationale in this case. But briefly, my Lord, that election petitions at trials are supposed to determine the merits of the case. So the only evidence you can have on record is through affidavit. If you sneak in inadmissible evidence, like hearsay, there's no any other chance of getting that evidence off the record. And my Lord, because we are not proceeding by witness statements, the only form we can have evidence on record is by affidavit. So where the deponent is giving information from other people who are not before court, my Lord, that information is not in not addressed.
As you have pointed out, paragraphs 10, 11, 12, 13, 14, 16, 18, 19, and 20.
Yes, my Lord, and
These are the ones that which I have captured here.
yes, my Lord, and lastly, to emphasize this, my Lord, even evidence from the advocate is not admissible. Even that from the advocate. And my Lord, I will quote that. Except the advocate who is representing the deponent. The affidavit where it reads that, my Lord, I have been informed by my foresight advocates. So, my Lord, the excerpt that is relevant to this situation from Zachary Alum. The ones from the advocates? Lord, we have paragraph 13. I'm informed by my lawyers, Messrs. Friend advocates. 14. I am further informed by my lawyers. Yes, my Lord. So, my Lord, the essence of my submission is that information one from the agents, if it is being quoted by Hajat Nambi and information from the lawyer, both are not admissible. They are closed out by the rule of hearsay, because she cannot speak or vouch for the truth of such statements unless we are going to have Mr. Kamel on the stand to speak to him.
Well, my lord, again, my understanding, because I have a right as a party. Yes, my lord. My lord, because an application, my lord, rooted out of these cases, a party can rightfully object admission during trial. If I object, yes, my lord, if I object, then it behoves that the other side has to be heard on this issue, even if it is to be determined later. That's my understanding. Then we can receive a decision, unless they choose not to. Yes, because for the specific.
My lord, I'm surprised by the objection, my lord, on a number of reasons. This time is referred to section 59 of the Evidence Act. Firstly, my lord, by dint of section 1 of the Evidence Act, that act does not apply to affidavits. By dint of section 1, that act, the Evidence Act, it does not apply to affidavits. Secondly, my lord, the witness in paragraph 23 of her affidavit in support of the petition clearly states that what she is stating above is true to the best of her knowledge and belief from sources she has disclosed. In each of those paragraphs that my colleagues have referred to, the witness has stated the source of the information. She has stated the source on each single one of them. And my lord, there is nobody that she has mentioned who has not deposed an affidavit in this court. All of them, every person she mentions in any affidavit, in any paragraph rather, has deposed an affidavit in this court, and the record reflects that. Decisions are bound, my lord. It is only hearsay. If she states where she gets information from, and the person who she's getting information from is not before court by way of an affidavit, that's the only way we can call it hearsay. But where, my lord, she states that Karule informed me, and she said Agent Karule is here with an affidavit, that ceases to be hearsay. And all of those affidavits of persons she referring to in her affidavit are before this court by way of affidavits. Now, my lord, I also tend to think that we are reading from different decisions of Basic and 7. My lord, in that case, Mulenga, JSC, who was part of the lead decision, held that my lord, I should, however, comment especially on affidavits required under Rule 4, Sub-Rule 7, and 83A of the Election Petition Rules to accompany the petition and answers there. The said rules require that those affidavits shall set out the facts on which the petition is based, and the respondent will rely on, as the case may be. Invariably, however, the parties have to rely heavily on factual information they receive from their agents and other witnesses in order to comply with that requirement. In my view, this is what Mulenga says, in my view, therefore, in relation to those affidavits from those other agents, Order 17, Rule 3, which I think back now is 19,
of the CPR has to be applied with such modifications as permits the petitioner and the respondents to include in those affidavits facts which they depend on such information. My Lord, that decision was referred to by the Court of Appeal in the case of Mpanga, Farouk versus Senkuge Isaac, and I'm reading from that decision. After quoting all of that, my Lord, their Lordship said in the Court of Appeal, after quoting that part of the decision, that in the instant case, a reading of paragraphs 5A to M of the petitioner's affidavit, just like in this case, my Lord, shows that what was stated therein was information based on what was provided from polling agents and supporters, as in this case. The petitioner, their Lordship said, the petitioner clearly disclosed the sources of his information, who also saw affidavits in support of the said allegations based on their knowledge, as has happened in this case. Then they held their Lordships in Senkuge, last round of elections. They then held, we find that the learned trial judge found that the disclosure of sources of information by the petitioner was sufficient, following the majority decision in Kiza Besigye versus Museveni. That was the holding of their Lordship. It's not here. My Lord in Muhindo, Rehma. Muhindo Rehma versus Winfred Kiza, EPA number 29 of 2011. The Lordship said that in these cases, the candidates rely on appointed agents, and as such, should have included that specific source of information, as has happened here, in the affidavits, or else they file separate affidavits from the agents who witnessed the occurrences. That's what we did, my Lord. And the Lordships then held that the learned trial judge cannot be faulted over this aspect.
Okay.
So, my Lord, our submission is that first, the evidence act relied on doesn't apply to affidavit evidence. Two, the petitioner has disclosed all manner of sources of information. Three, those persons from whom she has sourced that information have all deposed affidavits and they are on court record. Number four, then the Lordships held that that ceases to be hearsay. Of course, the logic, my Lord, is a candidate is not expected to be in each polling stations out of the 197. She relies on information from supporters, from campaigners, from agents. It's only hearsay if she says, Mosisi told me this, and there's no affidavit from Mosisi. If that the case is, the affidavit is there, that ceases to be hearsay.
Yes, my Lord. For starters, whereas it's true that all these witnesses depose affidavits and that they disclose information that may be relied on, our submission is not premised. I use the word elementarily in the principle in section 59. Elementarily, it is cardinal. Evidence has to be of the witness who saw fracture. But our submission is rooted in Order 19.3.1 and 2. My Lord. We submit that hearsay evidence is prohibited. Even belief is prohibited under the law. The issue of information received is prohibited. It's our submission under Order 19, Rule 3.1 and 2. My Lord, why I raise this issue at this point? I was finding difficulty proceeding with agents who are already in question. They disclosed evidence information that she does not have, my Lord. To rest this point, my Lord, that is why it would be very proper that we expand those paragraphs at this stage. That was my submission. Because how then do I go there? how then do I go there? When I already have a ruling on record that you cannot cross-examine them. That's why I raised it at this point. He's telling me they are there. I cannot access them. The witness is saying, I don't know, I brought witnesses. It was from her evidence. So I'm at pains, my Lord. I would not have raised, made petition. So I pray, my Lord, and these cases, good enough, most of them somehow, both sides participated. They ourselves, and we know they are distinguishable. My Lord, to distinguish them properly, this my colleague submitted on the authority, just for distinguishing purposes, then the rest our case to that. I'm obliged.
What the decision I'm referring to, really loving that, my Lord. The decision I was referring to is the decision of Justice Odo in the 2001 election petition. My Lord, this is, I need to really offer a proper context of why, where you're using affidavits, the courts are very strict on what can be admitted. Also, after this side in the record. My Lord, in election petitions and constitutional petitions, the only way by which you can bring evidence is through affidavit. My Lord, the case goes further to state that hearsay, or what we can categorize as hearsay, would only be admissible in interlocutory matters. My Lord, say if I have suit and I want to get an injunction, then I can go to my lawyer, and my lawyer informs me that that plaint discloses prima facie a case, and therefore I qualify to be given an injunction. My Lord, that is the only way you can have hearsay evidence admitted on record in interlocutory. And my Lord, it does not help, especially for the petitioner, to bring paragraph 23. If Mr. Carole read the decision that I read, he knows that in fact was the foundation that all the affidavits that they sought to strike off the record had that statement that what we have stated, we have disclosed the sources and belief. And the court said, no, we cannot nullify or confirm a candidate of an election on the basis of one, belief, two, information that is sourced from another party. That is, my Lord, the rationale. But my Lord, I read the excerpt. It says that, this is from Semogere, it says that except in purely interlocutory matters, affidavits must be restricted to matters within personal knowledge of the deponent. Two, they must not be based on information or by expression of opinion. It goes on, my Lord, affidavits should strictly be confined to such facts as the deponent is able of his own knowledge to prove. Affidavits by persons having no personal knowledge of the facts and merely echoing the statements of the client cannot be used at the hearing. This is where we are. Hajat Nambi says Nalukoola is not a duly elected member of government. What evidence must court rely on? Hajat Nambi was told by her lawyers that there was non-compliance. Hajat Nambi was told by her lawyers that the election was marred by great violence that affected the results in a substantial manner. She does not have that knowledge. She is quoting other people, my Lord. That is inadmissible, my Lord. And that is, so my Lord, the issue of Court of Appeal, High Courts, it is really, Mr. Carole has an affair with it. We have a Supreme Court decision. And my Lord, we cannot go behind. We cannot go back, my Lord.
Agenda, I will consider this objection during the general valuation of the evidence.
Well, my Lord, that was really disenfranchisement, and the rest we can go to illegalities. Nambi. But some question. Right, Ajat Nambi. Let's go to paragraph 16. That's where we start now. The hearsay. My Lord, I'll go to it since if it is considered otherwise, not that I believe in it. 16:1. Is it your testimony under 16?